Are you struggling to figure out who your child should live with after separation or divorce? Let's talk about it. This is when you would need to consider a child arrangements order and see how a child arrangements order can help you and your family. A child arrangements order is a legal decision made by the court to establish where your child will live, who they will spend their time with, and how they'll maintain contact with each parent or guardian. These orders aim to prioritise the child's best interest above all else. The court will always consider the child's needs above both parents. If you or your former partner can't agree on child arrangements, the court will unfortunately need to get involved and will need to assess factors such as the child's age, needs and wishes, as well as the parent's ability to provide a safe and stable environment. Remember, the court won't automatically favour one parent over the other. Even if the parents have different views on who the child should live with, the court will consider all factors before making a final decision. In many cases, mediation is required before applying for a child arrangements order. The purpose of this is to give the parties a chance to try and mediate and reach an agreement outside of court, saving time, stress and costs. However, if mediation is unsuccessful or not suitable, the court process becomes necessary. An instance where this may be required is where there's allegations of domestic abuse or other sorts of abuse being made. It's also important to note that the court order is legally binding, meaning that both parents must comply with the terms. If one parent breaches the agreement, the other parent is legally allowed and should apply for an enforcement order. Child arrangements orders can be complex, emotionally charged, but they exist to protect your child's well-being. If you're unsure where to start or need some expert advice, feel free to reach out to us. Let's work together to find the best solution for you and your family and your child.